not be consistent or predictable in all persons. Thus, referring to the Michigan court, they held that the Frye test is inapplicable to such evidence.
Well, I don't think this is a Frye issue.
Yes,
I agree with you on that.
But it says, so long, though, as the purpose of the evidence is merely to offer an explanation for certain behavior. And that's all we're doing, is offer an explanation for certain behavior. I don't doubt for 1 second that counsel is anxious to get into 404B. I think when we say good morning, he'd like to get into 404B, but we'll talk about that tomorrow, Your Honor.
Right. I guess what I'm saying is your expert can testify about what she saw was consistent with anxiety, consistent with a panic attack, consistent with somebody suffering from claustrophobia. I think the problem is if she actually starts talking about PTSD, I think that opens the door to a lot of things. So I'll think about that a little more as far when we get there. But I think if it's limited to consistent with those things, we avoid the dangers of having experts talk about state of mind. Yeah, Mr. Nelson's going to say that Mr. Floyd was resisting arrest. He's entitled to argue based on the evidence. As the state is going to argue in response, no, he was claustrophobic. This is not an act, is what they're going to say.
Correct.
And so I think that's the difference. And so, and certainly the state, I'm sure, will be arguing that in closing. So it's your interpretation doesn't tell me what I'm going to allow the expert to do is where I'm at. Either side, I wouldn't expect. Just because it's your argument doesn't mean I'm going to let an expert testify to it.
Right.
So,
all right.
Okay, I think we pretty much have the limitations there.
I would like to make a record, Your Honor.
Sure. Why don't you do that?
Your Honor, and I know that we're short on time today, but I am gravely concerned, and I know we've been dealing with these motions this morning, but I am gravely concerned with the news that broke on Friday relevant to the civil settlement in this case. This is, by my count, notwithstanding all of the high-ranking state officials that made comments at the onset of this entire situation. But by my count, this is the third highly prejudicial and incredibly prejudicial press leak or press release that has very suspicious timing, to say the least, and has an incredible propensity to taint a jury pool. Because what we've been hearing from the jurors who've come in so far is they may run into a headline record $27 million civil settlement. If there's and the court has granted permission for these people to be scrolling through Facebook, it's going to be unavoidable. And I think that there are certain things that the court should strongly consider. I think there are things that if the court denies those requests, there are things that the court should potentially be obligated to do to protect the jury from future questionable press releases. One thing I think the court should strongly consider is a request for a continuance, Your Honor, and a renewal of our change of venue motion. The fact that this came in the exact middle of jury selection, it's perplexing to me, Your Honor, that whose idea it was to release this information when it was released. When we have jurors in the courtroom, we have jurors seated in this case, and we have 7 more jurors to potentially find. If the court is not inclined to continue or change venue, and we can address these again further, I think there are things that the court must do, which include calling back the 7 jurors that are currently seated on this case and inquiring. I think there needs to be specific inquiry as to this settlement. It's amazing to me is, you know, they had a press conference on Friday where the mayor of Minneapolis is on stage with city council, and they're using very, what I would say, very well-designed terminology. The unanimous decision of the city council, for example. It just goes straight to the heart of the dangers of pretrial publicity. In this case, I I think the court should also strongly consider providing the defense with extra strikes. It's another potential remedy. And I think the court should strongly consider the immediate sequestration of jurors throughout the pendency of this case. And we can address these things, but
I'll let the state respond because you have several motions in here, basically. Continuance of the trial, calling back the 7 and voir direing them regarding any exposure to this information, and for extra strikes. And the jury is not quite ready. They're not going to be ready till at least 9:10. So I'll ask for the state to respond to those.
Judge, I would also just...
And I'll take all that under advisement.
I would also just simply add that I think that in view of some of the press that came out over this weekend in terms of where this information came from, I know that in the companion cases there was a pending motion of, a pending motion of one of the other defendants for a hearing, and I think that this would be a proper subject of that hearing as well.
Mr. Slisher?
Thank you very much, Your Honor. If it pleases the court, with respect to the actual news of the $27 million settlement, all I can say to the court is there are some things that the state of Minnesota and this prosecution team can control, and there's some things that the state cannot and does not control. We can control the witnesses we call, we can control the evidence that we bring in, we can control the motions, but we cannot and do not control the civil aspect of the case. We cannot and do not control the Minneapolis City Council, and we certainly cannot and do not control the news cycle. The media reports on what they report on things that they find of a public interest, and apparently they've done so here. I would also urge the court, just like everything else, take a step back, look at the actual effect. And through the process of jury selection, what we've seen here, Your Honor, is that while individual jurors have been exposed to media in the case, and they certainly have, the jurors that we've seated have expressed that they can set anything that they've learned outside of the courtroom aside and judge the case based on the evidence. And there's no reason to believe that our future prospective jurors, who we're going to be questioning later today, won't be in the exact same position. There have been some stories that have come out that haven't even been mentioned in our voir dire thus far. And so whether or not a juror learns of a civil settlement in this particular matter, it really is a subject for individual questioning and individual review. You know, in terms of the sort of inference that this was somehow coordinated by the state of Minnesota, it wasn't. I don't know even how it could be if we wanted it to be. And as far as the language that was used by those people who were speaking, I certainly didn't see what comments they were going to make before they made them. It seems to me if they reported a unanimous decision of the city council, it was because all of the city council members agreed with that decision. And so I think that we need to reflect on that a little bit and also just continue with the voir dire as it's been. As the court noted, we had a prior exchange in chambers. The court has...
You would agree it's unfortunate, wouldn't you?
That it's unfortunate?
That we have this reported all over the media when we're in the midst of jury selection as far as...
Yeah, it's certainly not my preference, Your Honor. I don't even know which way that cuts. If that cuts for us, if that cuts against us. You know, some jurors
The problem is it cuts.
What's that?
The problem is it cuts.
Yeah.
That's the concern, and I think the defense has a legitimate concern. I think the state even has a concern.
Absolutely. We are. It would be our strong preference that we'd be trying this case in a vacuum with no pretrial publicity. It certainly would. It would make things a lot less complicated. But that's just not where we are, right? I mean, this is the case that we have. The court has taken some pretty substantial measures in this regard to protect against any negative effect of pretrial publicity, including tripling the number of strikes for the defense and for the state that would normally be allowed in a case of this type. And we haven't even used them all yet. Neither of us have. And so I think that the continuance motion for that basis, obviously the state has moved for continuance as before, but I would oppose a continuance on those grounds, Your Honor, because I don't think it's warranted. I would oppose any extra strikes at this point as being premature. I wouldn't be surprised if the jurors we questioned don't pay as much attention to us as we think they do and don't know about the settlement. Maybe they do, maybe they don't. But I think that that's something that we should take up with individual questioning. Let's wait till we have a problem before we start thinking about a solution.
Yeah, there's been, I think, what has to be characterized as prejudicial pretrial publicity, not just about this, but on other matters that we've tried to dance around, or I've tried to dance around with the jurors. And I'll do the same, and I might even be a little more specific and talk about, or have you read anything about any pending civil litigation? So I don't think it's appropriate for extra strikes, because if they have read something that makes it that they cannot put that aside, I think it's more a matter of more likely a challenge for cause. So I'm actually going to deny the motion for extra strikes. I'm going to grant the motion that at some point, probably after we are finished selecting, that we call back the 7 to see if there's been any if they've read anything and if it changes their minds about whether they can be fair and impartial. I think the defense is entitled to that, and I wish people would, city officials would stop talking about this case so much. But at the same time, I don't find any evil intent that they are trying to tamper with this criminal case. I think it's just the civil litigation was going on, and I'm guessing that both sides said, one side said, well, the result of the criminal case could go one of two ways. For one, it would probably raise the amount that has to be paid, and the other result, that it would lower the amount that would be paid. And so I think they all kind of, the timing is not related, I don't think, to this case. I think it's related to just their calculation about exposure, liability, and that. So I don't, it's unfortunate, and I wish they hadn't done it, but I don't sense any evil intent on the timing.
Your Honor, I would just note in the Nor case, within 24 hours of the verdict is when the civil settlement was announced. And unless those parties within 12 to 24 hours suddenly reached a complicated decision, we've got a mayor who's a lawyer by trade. He should know better, Your Honor. And obviously, Mr. Ellison's son is a city council member. And I'm not accusing Mr. Ellison of anything. I just want to make that very clear. But it is, it is profoundly disturbing to the defense, because ultimately the goal of this system is to provide a fair trial. And this is not fair.
Like I say, I think it is unfortunate. We're going to continue to proceed for now. I am taking your motion for a continuance of the trial date under advisement, however.
Your Honor, if I may just
Sure.
please respond to the inference, and I know counsel is stating that he's not accusing the Attorney General of anything, and for good reason, because there's nothing to accuse him of. His son's on the city council. They're not coordinating anything in this regard. The mayor is a lawyer. The mayor has a job to do. Certainly doesn't take direction from me. I don't think I've ever met him. These are just things that happen independently of what we're doing here. I think if we let them focus on their job, I don't know what happened in the Nor case with the civil settlement, wasn't involved in it. But if we let them focus on their job, we'll focus on ours of giving the defendant a fair trial and proceeding with jury selection. This is probably going to proceed just fine. The change